Your nosy neighbors hear noises they don't like, and they think it's coming from your house. So they call the cops and make a noise complaint. The cops show up at your house and they see your garage door wide open. Can they just walk in and start looking around? I'm Jeff Hampton, former prosecutor turned the people's lawyer, and today we're covering two primary points. One, can an officer ever force their way into your garage to look around, or maybe walk into an open garage searching for either you or anything in the garage because your neighbor made a noise complaint? Then number two, what if that garage is not part of your house, but instead a detached garage? Does that change anything? Can the police do more in that situation? Stick around, because knowing your rights and exercising them the right way can be the key to stopping cops from searching your garage. Situation number one. Can cops walk in and search your garage just because your Karen neighbor made a noise complaint? Before we can answer this question, we must first identify where and how the garage plays into your Fourth Amendment protections under the United States Constitution. The Fourth Amendment makes it clear that the right to be secure shall not be violated unless there is a proper warrant with sufficient probable cause. But unfortunately, over the years, the United States Supreme Court has created exception after exception. Now, we've previously covered on this channel how the home is the most protected place of privacy under the Fourth Amendment. In the case of Payton versus New York, the United States Supreme Court made it crystal clear that in the absence of a legitimate emergency situation, the police must have a valid warrant to enter someone's home to search or arrest. As Judge Fernandez emphasized in United States versus Albrechtsen, nowhere is the protective force of the Fourth Amendment more powerful than it is when the sanctity of the home is involved. The sanctity of a person's home, perhaps our last real retreat in this technological age, lies at the very core of the rights which animate the amendment. Therefore, we have been adamant in our demand that absent exigent circumstances, a warrant will be required before a person's home is invaded by the authorities. But wait, we know the Fourth Amendment applies to our home, but is the garage considered part of our home, or is it something different? In the Ninth Circuit case of U.S. versus Awaka, the cops tried to argue that your garage should not have the same level of protection as the inside of your home. However, cops can sometimes be wrong when they argue this, because there can be times where your garage can be a part of your home's curtilage. Curtilage is the area immediately surrounding the home where what the courts have called private family activities occur. This could be your decks, your porches, and sometimes your garage. In fact, the United States Supreme Court has said that curtilage can be considered part of the home, just as protected as the inside of your home under the Fourth Amendment. In Oliver versus United States, the Supreme Court defined curtilage as the area to which extends the intimate activity associated with the sanctity of a man's home and the privacies of life. In plain English, if it's where the private activities of your home life take place, it should be considered protected curtilage. The Supreme Court went on to rule in Taylor versus United States that a police officer's search of a garage without a valid warrant could be a violation of the Fourth Amendment. But wait, is the garage different than the rest of your house? Well, the Taylor court went on to say, and I quote, "We can conceive of no reason to distinguish a garage where people spend time, work, and store their possessions from a den or a kitchen where people spend time, work, and store their possessions. Simply put, a person's garage is as much a part of his castle as the rest of his home." Okay, so we now know a closed garage door can be a problem when the police try to enter into it or force their way into it because it's labeled as curtilage. But the police were relentless in the Oaxaca case. And the reason why is they tried to claim that they didn't need a valid search warrant or an arrest warrant if the garage door was left wide open. In fact, police and prosecutors went so far in their argument, they claimed that if you ever wanted Fourth Amendment protection for your privacy and property, that you must shut all of your doors and cover all your windows. Thankfully, the court responded to the cops and prosecutors' argument by saying that the Fourth Amendment doesn't just protect hermetically sealed residences. But in order to understand whether cops can actually walk into an open garage and do whatever they want, this brings us to the case of Payton versus United States. In Payton, the Supreme Court invalidated an arrest where police officers saw someone through an open door of a residence. They crossed over the threshold of that open door, entered into the room, and arrested the man. In holding that the arrest was unconstitutional, the court said, and I quote, The Fourth Amendment has drawn a firm line at the entrance of the house. Absent exigent circumstances, that threshold may not reasonably be crossed without a warrant. Here, because an attached garage is still considered to be part of your home, even if your garage door is open, the police can't just walk in and start searching without a warrant. Always remember, your attached garage always has the same level of Fourth Amendment protection as the rest of your house, so they can never enter, cops can never enter into your attached garage, even if the door is open, unless they have your consent, which you're never going to give them, or they have a real emergency situation known as exigent circumstances. But what is a true emergency that allows cops to enter into your garage without a warrant? That brings me to my next point. What if when your Karen neighbor made up that noise complaint, cops show up and take the claim of the noise complaint, and now they think you committed a misdemeanor? Can they use that as an excuse to come into your garage? Here, if the cops take what someone else says and they think you may have committed a crime, we're talking about the exigent circumstances exception to a warrant. Generally speaking, there are only 3 established exigent circumstances that allow a cop to enter into your garage. Number 1, the police better be able to prove that there's a danger of you destroying some type of evidence within the garage. Number 2 exception is the hot pursuit of someone fleeing a crime. And number 3 is a true legitimate emergency scene taking place. Let's say there's a heart attack or some medical issue going on. Let's be frank. Turning down loud music or some made-up complaint by your neighbor that the music was too loud, it doesn't meet any of these exceptions we just mentioned. But what about cops claiming that you were fleeing the scene of a crime by staying in your house and not coming out to talk to them about the noise complaint? This so-called hot pursuit exception is a trick cops use all the time, and it's important you know how to stand up for your rights with this, because it can be one of the most effective ways to bring a federal civil rights lawsuit against police officers when they violate your rights in this situation. This exact situation was addressed in the Supreme Court case of Lang versus California. In this case, Lang was pulled over because his music was playing so loud in his car, cops thought he had committed a noise violation. The problem for the cops is that Lang was only 100 feet away from his own house and his own garage. So he just pulled up into his garage, got out of his car, and walked into his house and ignored the cops. Cops then walked right into Lang's garage and started asking Lang questions in order to investigate him for DWI. The issue? Can cops just follow you into your garage to investigate you if they think you've committed a crime? Yes. Cops can follow you into your garage if the supposed crime you've committed that they think you are fleeing is a felony. But no, if the supposed crime is a misdemeanor. Lang made it crystal clear that they will not allow cops to use ticky-tack misdemeanors as a way to violate the privacy of your home. Now, what if cops ignore this ruling by the Supreme Court and they follow you into your garage anyway? Are there any consequences? Under French versus Merrill, if cops ignore what the Supreme Court has said about this, and they enter into your garage anyway, you can actually bring a federal civil rights lawsuit against them, and the Supreme Court has said they will lose qualified immunity. But wait, maybe the cop's smarter than this. Maybe he knows he can't walk in, so instead of walking in, he decides to snoop around the garage, look through the windows, and see what he can see. Is this legal? This exact situation happened in State versus Sochi. Police were smarter here. They knew that they couldn't just barge their way into the garage, so when the man, Sochi, refused to come to the front door or to answer any questions or to step outside, they began to look through the windows of his garage and snoop around the garage. Ultimately, the New Hampshire Supreme Court ruled that based upon established U.S. Supreme Court law, that it's a violation for the police to walk around snooping and looking through the windows of a garage without a warrant. The key point, though, is that the court said that they ruled that this particular garage was within the curtilage of the home. So now they said, would any other person, just some visitor, be allowed to walk around and snoop through the windows of the curtilage of your home? Of course not. As a result, the police couldn't do it either. So what's the key takeaway? Police cannot just go nosing around, snooping around, looking into the windows of your garage, as long as your garage is considered curtilage. Which brings us to the ultimate final question. What if you don't have an attached garage, but instead you have a detached garage? Is this considered curtilage? Now, in the Supreme Court case of Oliver versus United States, The Supreme Court also ruled that you have no reasonable expectation of privacy in areas that are outside your curtilage, sometimes referred to as open fields. Here's the risk. If your detached garage is considered an open field and not part of the curtilage, cops don't need a warrant in order to show up, snoop around, look either through the windows of your garage or look right through to search the open garage door, even if you put up no trespassing signs to the public or the police. In fact, that's exactly what Oliver did in the Supreme Court case we just mentioned. He put up no trespassing signs and he locked his gate. I know, I don't like it either. We can keep the general public away from our open fields, but we can't keep cops away. When I was in law school, I got into a serious car accident. I was injured, overwhelmed, and at the time, I thought hiring any lawyer would be enough. I didn't realize how much my case was actually worth, and by the time I did, it was too late. Here's the truth. Insurance companies are in the business of paying out as little as possible. They often start with lowball offers, hoping you will accept them before you realize how much your case is worth. If you've been seriously injured, you can check out Morgan & Morgan, America's largest injury law firm. Morgan & Morgan's results speak for themselves. Just recently, Morgan & Morgan helped clients achieve $12 million in Florida, 34 times the highest insurance offer. A $26 million settlement in Philadelphia, 40 times the highest insurance offer. They have experience fighting for injury victims and going after the compensation you deserve if you're their client. Here's what makes them different from everybody else. No upfront costs. You pay nothing unless you win your case. They make it super easy for you to start your case in just a few minutes right from your phone. And most importantly, they have a nationwide team of attorneys ready to take on the big insurance companies. If you're wondering how to get started, it's actually really simple. You can go to their website, answer a few questions, and submit a claim without ever having to leave your home. I wish I had known about Morgan & Morgan after my car accident. Don't be like me and trust the insurance company. If you've been seriously injured in a car accident, workplace injury, or any personal injury, your case may be worth more than you think. And you're only a few clicks away from finding out. You can check out Morgan & Morgan at www.forthepeople.com/Hampton Law. Or scan the QR code on the screen to learn more. If you've been seriously injured, you owe it to yourself to know your options, and Morgan & Morgan fights to get their clients the compensation they deserve. But wait, how do we know if our detached garage is considered curtilage or an open field? This is where the Supreme Court gave us a 4-point test to apply to our situation. Number 1, the proximity of the area being searched by the police to your home. Generally speaking, the further away your detached garage is from your primary home, the less protection you have under the Fourth Amendment. Number 2, is the searchable area within what the court calls a single enclosure of the home? In other words, is it connected or is it within the main fenced area of your home? If not, if you really want to stop cops from searching your detached garage and maintain your privacy, you need to actually put up a fence that not only covers your main home, but also fences in your detached garage under one single enclosure. Number 3, what is the use of the area? The court focused on, is it being regularly maintained? Is it an area that it looks like the occupants of the home are using on a regular basis? So if your detached garage is run down or dusty, doesn't look like it's being kept up, there's a good chance you'll lose this particular point on this test. So if you want to maintain that privacy, you need to make sure and keep it up. Make sure it's well maintained and it looks like someone's using it regularly. Finally, number 4, what steps did you take to keep this area from being seen by the general public? If you left your detached garage wide open, there's a decent chance you could lose this argument here because you made it easy for someone from the general public to walk up and see what's going on inside your garage. Okay, so let's say we now can take steps to protect our detached garage and make sure it's considered part of our curtilage. What if the cops now show up claiming they have a warrant for your detached garage? This brings us to the case of Ronquillo versus United States. This case was interesting because the cops showed up to this Colorado man's home with a search warrant that specifically stated they were there to search for drugs in his house, but it didn't mention anything at all about the detached garage. The officers just went ahead and searched the detached garage anyway, claiming, well, it's still within a fenced area, even though it was 25 feet away from the house. Ultimately, the police went in, found Ronquillo asleep in the detached garage, and found some drugs. Now, Ronquillo argued that this was a violation of his Fourth Amendment, but the 10th Circuit ruled that they applied this four-part test to this situation and said that the detached garage was still considered curtilage that was attached to the private home. They said the detached garage was close by, it was fenced in within the private home area, it was being used regularly because Ronquillo was asleep in it at the time they walked in, and apparently a lot of the windows had been boarded up to make it very difficult for anybody in the public to see what was going on inside. So here's the key takeaway. If police do get an actual warrant for your home, it is going to by default include your garage. And it could include your detached garage that allows them to search, even if it's not listed, if that detached garage would be considered to be a part of your home's curtilage under the four-part test we just discussed. Oh, and by the way, you should always keep your garage door closed anyway, because you've always got to remember the plain view doctrine. And under the plain view doctrine, if a police officer can stand from a public vantage point and look into your garage and see something that they may think is illegal, they can use that now as a basis to establish probable cause to potentially search, regardless of these rules we've just covered. Now, before I give you the 8 tips to stop cops from searching your garage, the one thing I also want to cover, because people ask me this all the time, is what if my car is parked in the garage? Can cops then come in and search my car, not just my garage? This is where we're going to say, number one, if you park your car in an attached garage, police cannot just come in and search that garage or your car without a valid warrant. But what if you're parking on a detached garage? This is exactly the Supreme Court case of Collins versus Virginia. And here's the rule. If you park your car in the curtilage of your home, which would be an attached garage, you have the same Fourth Amendment protections as your home itself, and the cops cannot enter into your garage to search your car without a warrant. However, if you park your car in the open fields area, which might be a detached garage that might not be considered curtilage, there you have no expectation of privacy, and cops can start snooping around, looking in the windows, potentially searching your vehicle without a warrant. So, what's our lesson? If you want to make sure that your car's privacy is protected, you need to make sure you always park your car within the curtilage of your home, which would be at least within the attached garage of your home. So what are the 8 tips to stop cops from searching your garage? Might seem simple, but number one, keep your garage door closed and secure. When you're not actively using your garage, keep the door closed. Otherwise, if you leave it wide open, it's an open invitation to both the public to snoop around as well as the police. Additionally, lock your garage's side entry doors and consider using blinds or curtains or something to blot out the windows on your garage, because the more you treat it this way, the more you're making it clear you have an expectation of privacy. Number 2, mark your private territory. Make it clear where your private property begins. If you have a detached garage, consider fencing off your yard, or at least the area that includes that detached garage. If you have an area near your home that you're concerned might be considered an open field, put up a private property no trespassing sign. Even though this legally will not keep cops from coming into an area they think is an open field, you're making it crystal clear so that you will have a court argument that there is an expectation of privacy and that it's reasonable, because you've let not only the cops know this, you've also let the general public know they are not welcome on this portion of your property. Number 3, never consent to snooping by the cops. If police show up and ask to take a look in your garage, you always have the right to say no. You can be polite, but you can be firm with the officer. I always advise you stay within the protection of your castle, within your home, and you can tell that officer, you don't even have to open your door if you don't want to, you can tell the officer, I do not consent to a search of my home, including my garage. You can then ask, do you have a warrant? If the cops don't have a valid search warrant, you can literally ignore them. You don't have to say anything or do anything. And here's a key important factor as well. You need to always instruct the other members of your household never to consent to a search, because otherwise you could end up having kids, you could have roommates, you could have other people that will walk up and have that conversation and go, sure, come right into the garage, take a look around. And in reality, if the cops had a good faith basis to believe they had been given consent, this could hold up in court. If the cops do have a warrant, ask to see it. You need to first check and make sure that it was signed by a judge, and then look to see specifically the areas that are being allowed to be searched. Now look, I don't expect you to be a legal expert when you look at the warrant, but Many times, you want to at least be able to tell what was listed on the warrant in terms of the area to be searched, because you can use this later in court to argue that the actual area that was searched exceeded the scope of what was provided for in the warrant. After you have looked down and seen what it says here, you look up at the officer and you say, "Officer, I do not consent to any search that exceeds the scope of what's listed within this warrant." Number 5, don't invite trouble. I know this sounds like common sense, but don't leave anything sitting in plain sight that a police officer might interpret as being criminal. The goal is not to provide any temptation where the police will even care about your garage. And even though the Fourth Amendment may protect you in court, the goal is to never have to spend the resources or the time in order to defend yourself in court. Number 6, always install security cameras, and ideally put a security camera in your garage. The number one way to establish police have made an unlawful search and potentially could be subject to an actual civil rights lawsuit is to have video footage of an officer illegally walking into your garage and searching and looking around. But without that footage, many times it's your word versus the cops. You say, "But come on, Jeff, why do I need that? I mean, cops are supposed to wear body cameras, right?" But you know as well as I do, sometimes the officers turn off their body cameras or they cover them up, and you don't always have what you need to show what happened. Number 7, stay calm and record everything. Look, if a police officer persists in violating your rights and entering into your attached garage or detached garage and looking around, you can pull out your phone and discreetly record everything that's going on in addition to the security camera you already have. And you want to reiterate during this entire encounter, that way your phone is recording this, "Officer, I do not consent to the search of my garage, and you are now trespassing onto my property, and I'm demanding that you leave." Finally, number 8, always consult an attorney if a police officer has violated your Fourth Amendment rights on your curtilage. Not only can a good attorney file a motion to suppress to throw any evidence they obtained out in court, but a good lawyer may also be able to bring a civil rights lawsuit against those police officers, because if they did violate your constitutional rights under the Fourth Amendment, when it comes to your curtilage, they have no qualified immunity and you may be able to recover for the damages you received. By following these tips, you're not only protecting the privacy of your garage, you're standing up for your rights. But what if cops now realize they can't enter in through your garage? So instead, they go up to your front porch and they cover your security camera. What can you do here? How do you protect yourself? Check out this next video where I break down how to stop cops from covering your porch cameras. See you over there.